Hello and welcome once again to the Raging Introvert. Today, we're going to take a look at some of the discussion about the Second Amendment and gun control. Unfortunately, we've had another school shooting here in the U.S. That means that gun control becomes the topic of the week. And this video, as with many discussions on the Second Amendment and gun control, get a lot of things wrong and are presented from a perspective of trying to get support for increased gun control and diminish the meaning of the Second Amendment. So let's take a little look here.
We all now know about the Second Amendment. We hear about it all the time.
Perhaps it's a minor just annoyance on my part, but we should already know all about the Second Amendment and the other amendments from school and learning about our government and our Constitution. It shouldn't take events like this to bring the discussion up. It should already be part of our basic knowledge as adults in the United States, as citizens. Just a minor point that bugs me.
It is a huge driver of our politics on the right.
Notice how he says it's a huge driver of politics on the right. Currently, it's just as big a driver of politics from the left. And in fact, the right probably wouldn't have brought up and focused on the issue of gun rights if the left first hadn't brought it up in relationship to trying to have more and more restrictions on guns, gun ownership, what kind of weapons, who can own them, how many, all of those things. And he'll get into it a little bit later. None of this would have come up except for the left pushing the issue first and then the right coming as a counter-argument. They're the ones who are always perpetually outraged at something and agitating for infringement of rights guaranteed in the Constitution.
What people need to know is that the Second Amendment only recently became such a salient amendment.
And he's absolutely correct here. For centuries, really, it wasn't a big issue. The amendment was there, people owned weapons, and no one really had an issue with it until the 60s and 70s when they started trying to push more and more restrictions, and people on the right started resisting and pushing back.
Here's the Second Amendment. A well-regulated militia being necessary to the security of a free state. Let me repeat that. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Well, first of all, what did that mean, the Second Amendment, back in the 1780s and 90s when the Constitution and its first amendments were written?
Ooh, I know, I've got this one. I've got the answer. It meant exactly what it said. The founders who wrote the Constitution and the amendments thought that militias were essential. Two things. It said for the security of a free state. If it was just for security from an outside threat, it would just say for the security of a state. But it's not just about arming the people to protect against external threats. To maintain a free state, who would oppress you within the state? It would have to be the state itself, or the government, or the higher level, the federal government. The Constitution and the Federalist argument, the concerns about the Constitution, were that a federal government would grow in power, would become too powerful, and could potentially become tyrannical. Just like the federal government of England that they had just rebelled against had. So that's the context. The context is the people writing the Constitution and writing the Bill of Rights and the amendments are trying to protect rights of the people from a potentially tyrannical government. The founders thought that militias were the key to that, which is the first part of that clause. Militias are essential to the preservation of a free state. Therefore, the people have the right to keep and bear arms, and it will not be infringed. In the militias, people own their own weapons, They weren't provided most of the time, and they were entrusted with weapons that at the time were cutting edge and had successfully defeated the most powerful nation on the planet in a revolution. So that's the context. Let's see what he says.
It meant because the new United States would have no standing army, that any armed defense of the states or the United States would depend on militia who would be mobilized to fight the fights they needed to fight.
So it sounds like Mr. Anderson and myself and the Constitution are all in agreement then that it does entrust people, the citizens of the nation, with the right to own weapons of war because they had them, they used them successfully. One thing I noticed he did leave out that's kind of important is some other contextual information. See, here it says the Second Amendment was adopted on December 15th, 1791. There were some other important events going on around that time, right beforehand, that you would think may have impacted the decision-making of the people writing and ratifying the Constitution and the amendments, I mean. So, for example, we have Shays' Rebellion, 1786, 1787, 4,000 armed American insurrectionists attempting to seize an armory and causing all sorts of problems. That should have been something taken into consideration when writing the Second Amendment. And perhaps the Whiskey Rebellion, again, another armed insurgency to the point where the president at the time, George Washington, actually assembled an army and led it into the area to put the rebellion down. Now, you would think that with that relatively recent, this was beginning in 1791, so that was ongoing at the time of the ratification. You would think with those recent events in the back of their minds, if there was a concern about individuals armed with weapons, and they've rebelled against the government twice already, maybe the amendment would have been rewritten in such a way that, maybe the rights of the states, the state militias, to keep and bear arms, because these were not rebellions launched by the militias. These were rebellions launched by individuals banding together and confronting the government, armed insurrection. You would think maybe the Constitution would have put some better control measures into that, but they didn't. They left it the rights of the people to keep and bear arms would not be infringed. And I think that's an important distinction that he doesn't bring up. And when you're talking about context, this is kind of important.
So there's that. Another important fact about the state of play when this amendment was written was the nature of arms themselves, of guns. A really good shooter could fire 3 or 4 rounds a minute. And that's a really good one with these poorly aimed muskets and early rifles.
This dumb argument gets brought up every time this discussion comes up, that, at the time it was only muskets, so the founders could never have perceived or thought of much more destructive weapons, and if they had, maybe it would have changed something. I don't get it. He even admits that was the most technologically advanced weapon at the time, and they entrusted people to have it. The Constitution and the amendments are about principles. They don't, as technology and time passes, fundamental principles should remain the same. And I don't think he's so stupid that he actually believes that, for example, the First Amendment only applies to the printing press and town criers. It applies to YouTube. It applies to radio and television. Just like the Second Amendment and gun rights apply to modern firearms and not just old ones. So why does this get brought up then? If he's not too stupid to believe that the technology makes a difference to the principle, it's because he's trying to mislead and misdirect people. Those that are either sympathetic or that are dumb, it would find that argument convincing. On a second note, he mentioned 2 or 3 shots, but they're inaccurate muskets. If he actually was a scholar and did any research, the militias of the time were actually armed with rifles that loaded slowly, but were actually very accurate out to range, which had pros and cons for the militia. The militia members were armed with weapons they hunted with primarily, and then they would use those weapons for war. So it was more like the militias were armed with sniper rifles. But he's a liberal hack who doesn't actually care about the facts and didn't do any research. He's just here to make a political point.
Muskets and early rifles that they had. So that was what was being regulated. It was, oh, let's have a militia, and they can use these guns, which were the state of the art, but compared to.
And this next bit was very subtle. It's a very subtle sleight of mouth, sleight of hand. He says the idea was, oh, let's have a militia, and they can use these guns. That's not actually what it says. It says militias are essential for the security of a free state. The people will have the guns, and they will form militias. It's not so that the militias can have the guns. It's so the people will have guns and can form the militias. He's got it backwards, but it's a deliberate, subtle deception to make it sound like the amendment is talking specifically about giving certain rights and responsibilities and capabilities to the militias, when it's not. It's saying militias are important. That's why we're giving the people the right to have the weapons so that they can form militias. That's not what he wants to present it as. That's why he's using this slight deception in his words, but that's the actual purpose behind the verbiage.
Which were the state of the art, but compared to many, many, many rounds per second firearms that we have today, it's the same word, but virtually a different machine.
Yes, again, like the printing press compared to a modern word processor, or a theater stage production versus a YouTube video. The principle remains the same. The technology is irrelevant to principle. So why are you bringing it up, you hack?
So fast forward, or slow forward. For centuries, the Second Amendment didn't really come up. People had guns, they hunted, not everybody, but that's what happened. They used them for protection in rare cases.
Just like they always like to bring up that modern weapons shoot more quickly than the weapons at the time of the Second Amendment's ratification, they also like to throw in wherever they can hunting. Again, hunting, just like the difference between modern weapons and weapons of the time period, it's irrelevant to discussion. The Second Amendment is not about hunting. It's not about protecting hunting rights. It has nothing to do with it. They throw it out there to make it sound like they support some gun ownership, so they don't sound like they're complete ideologues going for a complete gun ban. Oh, hunting's fine, but this is beyond that. Also, he's saying that there wasn't much done on the front regarding firearms in the Second Amendment for hundreds of years after the ratification of the Second Amendment. They're used occasionally for hunting and very rarely for defensive purposes. Well, this might be a news flash to this guy, but the entire western 2/3 of the United States were pretty much conquered during that time period. There was a War of 1812 that the militias, armed with private weapons, were fairly active in. And the conquest of the West, while federal troops were involved, often relied on militias or individual farmsteads and homesteads fighting off Native Americans. Now, whether or not you think that the conquest and destruction of the Native American tribes was a good thing or not, again, is irrelevant. Firearms, modern at the time, cutting-edge firearms were owned by private citizens and were used quite frequently in defense of property and life as the nation expanded westward. He may have heard of something called the American Civil War. Again, state militias, volunteer groups were activated, ended up mostly being federalized, but they responded. But it wasn't just militias coming up. As the Civil War Trust website helpfully tells us, individuals would travel through their communities to raise regiments and present them to the army. In fact, at times these volunteer regiments would select their own commanders and sometimes provide their own uniforms and weapons. So private U.S. citizens were able to band together. There's no special legislation allowing this. They just did it. Private citizens banded together, purchased enough weapons to form military fighting organizations, and that was normal. That was par for the course. That was not unusual or unexpected. It was just, that's why no one questioned it. No one questioned it because, of course, you can gather 200 or 300 people, arm them to the teeth, and present them to the military to go to war. Why couldn't you? And that's how the Constitution of the United States has always been. Why can't you? Of course you have that right or that freedom. It's not about restriction. The only thing that's supposed to be restricted is the government from infringing on individual rights. During the Civil War, certain technological advancements came into place. The Henry rifle, a repeating rifle. Well, most soldiers were armed with, again, muzzle-loading, slow-firing weapons. This weapon, one of many, came out. What do we got here? It's a rifle. It holds 16 bullets. Lever action, so very quick firing, especially compared to muzzle-loading weapons of the day. Let's look. Oh, look. 6,000 to 7,000 saw use by the Union through private purchases by soldiers who could afford it. So, again, private citizens, no issue with them buying cutting-edge, super lethal for the time firearms. Again, no one batted an eye, no one blinked. It was just normal. Of course you can buy a 16-shot repeating rifle in an age of muskets and muzzle-loading weapons. Why couldn't you? And it's strange to hear him say that there was no meaningful regulation for several hundred years when the National Firearms Act, a fairly consequential piece of legislation in my mind, was passed in, 1934, which regulated the use of machine guns, sawed-off shotguns, explosive devices, etc. In fact, if we come down here, it was the United States versus Miller. Someone was arrested for transporting a short double-barreled shotgun, which was in violation. Basically, a sawed-off shotgun, which is in violation of the National Firearms Act. And the government argued the short-barreled shotgun was not a military-type weapon, and therefore it wasn't protected. So they're arguing that, of course, the only weapons that are protected would be ones that the military could have, and that's the only reason why a civilian could own it, would be because it's a military-type weapon. Not because it's less lethal or less capable. The citizens are only allowed or only protected to own military-style dangerous weapons or more effective weapons. It's strange how he didn't mention any of those things.
But it wasn't a big deal until starting in the 1960s, when suddenly, in a matter of months and a few years, a president, a presidential candidate, the great leader of African America and freedom, Martin Luther King, were killed, and other people attacked by assassins. Suddenly, it seemed to reasonable people that, oh, we should have some controls on who can get guns how easily.
He doesn't find it at all odd that a country awash in guns for, the founding in 1776, he's talking about 1960, so almost 200 years, of being awash in guns, he doesn't find it interesting that it takes until 190 years later for it to become an issue, and then automatically blame it on ownership of firearms or the guns. Maybe it's because the guns themselves aren't the problem, and instead there's some other root cause within society or culture or something else other than the weapons themselves that the country's had without major issue for the last 190 years. It's just strange that he wouldn't even show any intellectual curiosity about that and just assume the gun restrictions would be the correct solution.
So we enacted some very modest regulations about registration and limiting certain kinds of cheap weapons and so forth. And back then, in the late 60s and even in the early 70s, the National Rifle Association was reasonable, was fine. Okay, yeah, they negotiated these laws, but they were okay.
First of all, just just listen to yourself. Presenting as reasonable a law that limits the sale of cheap firearms. You know, well, if guns are fine, it's okay to own a gun, but only if you're rich. Poor people, poor people aren't allowed to own firearms. That's just ridiculous. Or, guns are legal. Guns are fine. It's okay to own a gun, but it has to be an expensive one because, I don't know. Because? I mean, that's really what it boils down to. Because. That's not how rights or principles should work. The Constitution is protecting principles. The principle is you as a private citizen can own a firearm without restriction. Well, I mean, there's some restrictions in it, but I mean, ultimately, the purpose is that you can own it and it shall not be infringed. Restricting things because, well, there's a dollar amount if it's too cheap. That's just ridiculous. But more important than that, gun violence was an issue in the 60s. Violence in general was an issue in the 60s and 70s. And yes, the NRA believed that other groups, liberal groups, were negotiating in good faith, and that the gun control propositions that were being raised were limited in scope, being offered in good faith, and were not a one step on the route to banning firearms. And I'm sure there are many liberals out there who did not intend on having it as a stepping stone en route to banning firearms. However, as time progressed, that's the direction things started going in. And he's going to talk about that a little bit. And we'll see there's a reason why the National Rifle Association went from generally open and at least interested in collaborating with gun control proponents to a much more hardline position.
Then, as so many things were going haywire in the national discourse in the late 70s, the National Rifle Association and the gun lobby more generally went out of its mind, to be blunt, and decided to be absolutist, that there would be no regulation of guns, and we would fight any regulation of guns. And moreover, that was all driven by a fantasy that the federal government was about to confiscate all of our guns that every individual had.
So just about everything he just said is absolute nonsense. As I discussed, and he conveniently overlooked, there had been some meaningful firearms legislation passed that was not a big issue, the National Firearms Act. And while the NRA and gun owners were not concerned that the government was going to immediately confiscate people's weapons, it was obvious that that was the end goal for many people. How can you tell? What kind of meaningful gun control measures were being and are still being proposed? large expanded magazine banning instead of a maximum of 10 rounds per magazine, an assault weapons ban, um, mandatory waiting periods before buying a firearm, uh, limiting the number of purchases someone can make in a month or a year. Uh, what none of those none of those are going to actually reduce the number of violent acts with firearms. Whether I have 30 bullets in a magazine or 10, yeah, okay, it slightly slows me down. But if I want to walk into a crowded area and start shooting at people, uh, maybe I kill one or two less. But ultimately, if I go in and still do a mass shooting, there's going to be a drumbeat saying that's not enough. We need to progress further. An assault weapons ban, it's mostly just cosmetic, unless you get very, very broad with your definition, which is what I'm assured is not the case by gun control proponents. And again, okay, what if I don't have an assault weapon? I have your 16 shot lever action rifle from earlier, from the Civil War we talked about. I can still walk in and shoot a lot of people. It's not an assault rifle. And if I do so, it's going to be a major issue. And what's the left going to do? They're not going to say, well, we've got enough gun control, let's look at something else. No, it's a one-way ratchet. And the only end state that can be foreseen from all these meaningless measures that will not stop mass shootings is eventually banning firearms and confiscation, except for maybe single shot or double-barreled weapons. Um, Tightly restricted, not possessed by people, but maybe locked up in firearm clubs. So that's why the NRA basically got smart. They looked ahead. They could see the writing on the wall, and really they took a page from the Planned Parenthood abortion lobby. The majority of people in America are supportive of certain restrictions. They don't want late-term abortions. If they hear about certain procedures like partial birth abortion, or they get informed about some specific things, maybe kind of like a waiting period. If someone's going to have an abortion, they have an ultrasound done, or are counseled and told about alternatives, including adoption measures or programs that will assist maybe a low-income mother, assist a low-income mother who thinks she can't afford a child with food and housing and shelter and medical care or whatever. The American public in general supports those. Planned Parenthood is not willing to sit down, discuss, and compromise. They are absolutists, and they resist any incremental change. And that's why they've been successful in preventing most of those slow progressions towards pro-life or anti-abortion positions. And that's why the NRA has also been very successful, because they stop. They resist every incremental step that is ultimately meaningless to the end state of preventing gun violence, and is against the Constitution and the law that it derives from. And in fact, you can see other things that the right and the conservatives in general have tried to support, or they've been in the past generally resistant to gay marriage. They've been in the past generally resistant to expanding welfare and national health care. In general, at least they say that they're resistant to expanding the government debt, and they're going to be more fiscally responsible. But with all of those issues, they've compromised and compromised and compromised, and the ratchet only has gone one direction. The only thing I can think of from a conservative perspective that has been relatively successful in stopping the one-way ratchet has been the NRA, and it's because they've been absolutists in resisting every incremental change.
So suddenly, the Second Amendment became a thing that people were aware of, and that was driving this passionate, fervent political faction. And the NRA, by the way, changed its motto from one about safe sporting and so forth to quoting the Second Amendment.
Yes, and that was in response. The NRA didn't initiate. Like you said, everyone left the Second Amendment alone, left gun ownership alone. It was fine as it was. And then the left started agitating for ridiculous restrictions like cheap weapons have to be banned. It's illegal to purchase a cheap firearm. Um, Meaningless, pointless, but infringements on people's rights. And that's what prompted a response from the NRA to counter those attempted infringements. And that's why they changed their mission statement. When the mission changes, your mission statement changes.
But still, for a while, for 20 years, the courts weren't buying it. This idea that the Second Amendment meant that we could not regulate the ownership of guns or the sales of guns.
That's because no one ever argued that the government couldn't restrict in some ways. No amendment is absolute in what it allows. And just like this, again, the National Firearms Act and other regulations, felons, it was illegal for felons to own weapons. They can lose their rights. People who are deemed mentally incompetent for whatever reason, if it makes them a danger, could lose their right to own a firearm. No one argued that. And again, National Firearms Act, machine guns, destructive weapons that are not part of a militia. That's what the Constitution is supposed to be protecting. And as long as the gun laws are not infringing upon that right for law-abiding citizens, it's not an issue. And it wasn't raised as an issue, which is why the courts didn't have to bring it up.
And by the way, we'd allowed, oh, you can't buy a machine gun, oh, you can't have a sawed-off shotgun. Those things happened over the course of the 20th century. Nobody said boo.
So you quickly mentioned in passing something that totally destroys the point you're making, because you have to acknowledge it. It's the elephant in the room. There are reasonable restrictions that both sides agree on. The Supreme Court and the legal system agrees on. The politicians agree on. Everyone agrees on. There are certain constitutionally certain restrictions to ownership that have been passed in law and are constitutionally sound that happened in the 30s. You'll just gloss over that because it's not a big deal, not a big deal. Well, it is a big deal. There are certain restrictions that can be passed and have been passed. The government and the people have addressed concerns, and let's be honest, did that act significantly change the scope of gun violence in the U.S.? It's still pretty easy to go out and commit a crime with a firearm. In some ways, again, that's kind of a meaningless law in the big scheme of things.
But suddenly, at the end of the 20th century, we had this ferocious and powerful faction interpreting the Second Amendment in a new way. Interpreting the Second Amendment in a new way that the retired Chief Justice of the Supreme Court in the 90s, after he retired, Warren Burger, a Republican, put in place by a Republican president, said, this is a fraud that people like the NRA are committing. This is not what the Second Amendment means. It's a fraud.
And yes, you have successfully shown that judges and the judiciary in general are not impartial arbiters of the law according to the Constitution and its principles, but instead are political hacks that twist the law to fit their beliefs instead of holding them accountable to what the Constitution and the original intent behind it was. So that's good. I'm glad we can agree to that. You've got one judge that you're presenting as an authority figure. I think you'll probably in a minute talk about other judges that did not agree with him. I wonder if you pay them the same amount of respect that you pay to this one. It's funny when you get to pick and choose which judges you respect and which ones you don't, depending on how their decisions fit your worldview instead of fitting the actual law.
He said. But they kept at it, and it became more and more respectable. This idea that the Second Amendment was absolute and applied to individuals who weren't members of the National Guard or any other well-regulated militia.
There's an awful lot of misinformation and misdirection in this little 18-second snippet. To start with, we've all already agreed that no one said it's absolute. We've already had restrictions on felons, mentally ill, machine guns, short-barreled shotguns. No one is arguing that those are inappropriate or improper or unconstitutional. And you have to love the, I don't know if I would say condescension, but just the way he phrased it. It became more and more respectable, this idea that the Second Amendment was absolute, which we've already discussed again. That's not what's being argued. And that applied to individuals. Now, yes, originally, as intended, the Bill of Rights and the Constitution in general was supposed to be about the federal government. It's supposed to be very limited in scope. And the Bill of Rights and the amendments therein were only supposed to protect individuals from the federal government. The states were supposed to be able to do whatever they wanted. And if a state wanted to ban all firearms, as originally conceived, that would have been fine. That was the intent behind it. But if we take a look, you may be asking yourself, wait a minute, states can't restrict my freedom of speech. The state police, they can't just kick down my door and search my home. I have constitutional protections against that. Where do those come from? Without going into all the details, here we go. The incorporation doctrine, which is where the courts, through the 14th Amendment, said that the first 10 amendments apply to all the states as well as the federal government. So it's not this, it's becoming more and more respectable, this idea that the Second Amendment applies to individuals. It's just bringing it in line with all the other amendments to the Constitution or the Bill of Rights applying to individuals and protecting them from the state-level government and infringing upon their rights. And again, when the Second Amendment says the right of the people to keep and bear arms, if incorporation doctrine is now being utilized with the other Bill of Rights amendments, then that right for the people to keep and bear arms is protected against the state government as well. And just as we've seen with election, you can't have a poll tax because it prevents the poor from voting. You can't have a literacy test. Even though, hey, I'm allowing everyone to vote, you're infringing upon their rights. A lot of these stupid gun control measures, I want to make a 1,000% tax on ammunition. Well, the right of the people to keep and bear arms, if you can't afford ammunition, then you're not really allowing them to exercise their right. All that stuff comes through here. Again, whether or not you agree with it or not, it's all consistent with this interpretation of the law. Ultimately, the founders and the people who wrote the Bill of Rights, they discussed it at length. They were not careless with their words. If they had intended for only militias to own weapons, then it would have said the rights of the states to keep and bear arms, or maintain arms, or maintain an armed militia. I mean, there's a lot of ways they could have phrased it. They chose the people very specifically because they wanted the people, the citizens of the nation, to be armed.
Was absolute and applied to individuals who weren't members of the National Guard or any other well-regulated militia. And finally, in 2008 and 2010, in two decisive, definitive, absolute decisions, the Supreme Court decided this new interpretation of the Second Amendment that had not existed in respectable legal circles 20 years earlier was the law, is what the Constitution meant.
First, we have an idea that's becoming more and more respectable, and now we've got this is respectable legal circles, which really respectable legal circles to him means liberals that ignore the Constitution to push their own political agenda. So when you've got one judge you can quote that you agree with, you're happy with him. But as you say, when the Supreme Court definitively makes a decision, suddenly you're not really a big fan of that. That shows the political nature of the judiciary once again. And I think it's also important. You keep bringing up the fact that this has never been brought up. This is a brand new concept. Well, just like you said, it hasn't really been discussed. It had not been an issue for almost 200 years. And only in the last couple decades has this question come up. So, of course, it's going to look like a new interpretation. The incorporation of all the different rights had to come about through Supreme Court cases. Miranda, with your right to an attorney and information that the police have to give you, that all comes from the judiciary being tested with certain questions. So questions had not been raised about the Second Amendment and restrictions or the freedoms that it protects. Those questions came up, and pretty consistently with the First Amendment and other incorporated rights, the Supreme Court said, yes, you have a right to own a weapon. Yes, you have a right to carry a weapon. That's what when it says bear arms. What does bear mean? If it just means carry it around your home, well, that's pretty much just keeping arms. Bearing arms must mean you're going somewhere with it. So, it's not crazy. It's not something that's out of whack with the norm, or let me check my notes. What's the word again? It's not something that's becoming more and more respectable in legal circles. It's an appropriate interpretation of the Constitution, the 14th Amendment, consistent with the incorporation of the other amendments. So it's not a big deal, unless you're an ideologue.
So that's now what our Constitution means.
No, it's always meant that. Well, the incorporation, after the 14th Amendment and the incorporation of the other Bill of Rights. But it's meant that for entirety. It's not like it just came out of whole cloth in the last decade or two. It's just finally been challenged and clarified so that it shouldn't be a question anymore. Not a change, a clarification.
I think, so as a result, any, I think, really meaningful regulation of the ownership of guns at this point is a political fantasy.
That's partially because your definition of meaningful doesn't actually match up with reality, and partially because the law and the Constitution as written don't support what you're hoping for. The nonsense I'm sure you support, again, like we discussed earlier, limited capacity magazines, banning assault rifles, mandatory waiting periods for purchase of firearms. Those aren't actually meaningful because they don't accomplish any things that you say you want to accomplish. And again, the purpose behind the amendment is to allow the citizenry to be armed to such a point that they're able to fight in a war. They have personal arms capable of fighting in a war, in a combat situation. You may not like it, but that is the intent behind it. So no, the current legal environment, and unless the Constitution is amended, the future legal environment should not support any of the putzing around the edges crap that you would call meaningful. even though they accomplish nothing. And the only thing that would be meaningful, that would accomplish your goal, some kind of nationwide gun ban and confiscation, is certainly not going to be allowed unless the Constitution is amended.
As a result, ironically, of the Second Amendment absolutists and reinterpreters and revisionists and fantasists having imposed their interpretation of the Second Amendment on all of us.
Revisionists and fantasists, his language is very degrading towards those he disagrees with. But again, just like it or not, the system has worked as intended. It was not questioned for many years, as he pointed out. Finally, in the 60s and 70s, they started pushing for gun control measures. An organization came up and opposed them. It went to the Supreme Court, and the Supreme Court, in the last decade or so, has finally ruled on the question. It had not been addressed before. And yes, the Second Amendment should be incorporated and applied to the states as well as the federal government, in line with all the other Bill of Rights. One other point that, it's interesting he didn't bring up, and most people just pass over as well. One other window into the insight of the founders, the people who wrote the Constitution and presumably would know what they intended. One thing that comes up if you look into it, not the Bill of Rights, but the actual Constitution itself, is something called a letter of marque. And here's what it allows Congress to do. Congress has the right to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. Now, what is a letter of marque, you may ask? Well, Constitution.com or ConstitutionUS.com has a handy little definition at the bottom here. Grant right of piracy. Document issued by a nation allowing a private citizen to seize citizens or goods of another nation. You see, back in the 1700s, 1500s, especially in the Caribbean, navies and militaries are very expensive to maintain. But nations would want to go to war or fight with one another. So one way of achieving that was through something called a letter of marque. I am England. I have outposts in the Caribbean. I'm at war with Spain, but I can't actually afford to send a navy over to fight with Spain right now. But I can grant a letter of marque to a trusted British citizen, and that citizen is now allowed by the government to go attack Spanish, or whoever they're at war with, Spanish assets, and as compensation would be to keep whatever they steal. So basically, the state is allowing you to act as a pirate in their name. And in fact, the term they use for that is a privateer. So what does that mean for a citizen? Well, if a citizen is actually going to be a pirate, he's going to have to get a ship, a crew, cannons, all sorts of firearms. So at least as intended, as written, the federal government fully intended that it may have a need to not allow citizens to buy those weapons. All it's doing is granting you a legal document saying that when you're acting as a pirate, you're doing it with approval of the U.S. government. The letter of marque doesn't say you may go out and arm a ship and arm people. It just says you can go out and attack our enemy, and as compensation, keep whatever you take from the enemy. That's a pretty powerful indicator to me that the federal government intended for private citizens of a nation to be able to arm themselves pretty heavily. And again, if you're going to be a pirate, and this was pretty common in the Caribbean, when you think of pirates and things, the age of piracy, actually the pirates came after England and the other nations became wealthy enough to have standing navies. They did away with privateers. and the handful of people that were left turned to actual piracy without any legal recourse backing of a nation. But this shows to me that they were anticipating citizens would be able to purchase cannons, ships, multiple ships, have a flotilla. That's a pretty powerful indicator that they would not be surprised that people would be armed fairly well as a private citizen. I don't know, just one last thing to throw in there. Hope you found this educational, entertaining. I'm sure there's going to be plenty more with the Second Amendment and gun control being topics du jour.